Booked a house and the layout changed later? Can a buyer get a refund under RERA or not? A family steps out of the sales office. There is a brochure in hand, a dream of their own home in their eyes, and that very layout is running through their minds, where the children's room, parking and open space all looked perfect. The booking amount has been paid. The agreement is being prepared. The family is thinking that the journey from a rented house to their own roof is now just a few steps away. But a few months later, that same dream suddenly becomes a question. The developer reveals that the layout has changed a bit, the parking arrangement is new, there is a difference in the built-up area as well, and the design will no longer be the same as before. Right from here, the fear begins. Will the buyer get the exact same house they had seen? Or will that very property on paper slowly change into something else after booking? This is the biggest question. If the developer makes a major change in the layout, design, area or parking after booking, should the buyer quietly accept it, or can they demand a refund? This question is not just about one family. Millions of people in India rely on brochures, floor plans, sample flats, site visits and sales promises while buying a house. Buying a house is not a small piece of shopping. It is one of the biggest financial decisions of life. Here, a mistake does not just cost money, it demands the price of many years of hard work. That is why RERA, meaning the Real Estate Regulation and Development Act 2016 was brought in. Its purpose was to increase transparency, accountability, and the protection of home buyers in the real estate market. After RERA, a developer cannot escape responsibility simply by showing a fancy brochure. They have to disclose the project registration, sanctioned plans, completion timeline, approvals, and important documents in the public domain. But the real problem comes when a buyer books a house after seeing a layout, and later the developer says that the plan has changed. Now the question becomes one of both law and trust. Recently, a case from MahaRERA gave important clarity on this very issue. The case was linked to a bungalow booked near Mumbai, whose total consideration was said to be more than 2 crore rupees. The buyers had booked the bungalow in July 2021. In December 2021, a registered agreement for sale was executed, and they paid an amount of around 50 lakh rupees to the developer. Possession was supposed to be given by June 2023. But later a dispute began because the buyer stated that changes were being made to the bungalow's layout, design, construction area and parking arrangement. According to the buyers, the final arrangement looked different from the property they had liked. For them, a house was not just a structure of walls, but the entire utility and convenience mattered. From the developer's side, it was said that the changes were communicated to the buyers. It was also claimed that the changes in the project were necessary because of government approvals and practical requirements. This means that on one hand, the buyer was saying that the promised layout had changed. On the other hand, the developer was saying that information had been given and the changes were as per the rules. The dispute grew so much that the buyers decided to cancel the booking in August 2022. Their allegation was that the developer gave an assurance regarding the refund, but later there was talk of payment delays and installments. MahaRERA did not treat the matter simply as a fight of buyer versus builder. The authority observed that because of the revised layout, parking configuration and related assurances, the contractual relationship had practically broken down. According to reports, MahaRERA ordered the developer to refund the amount paid by the buyer along with applicable interest within 60 days. But there is an important detail here. Taxes, stamp duty, registration fees, and statutory charges paid to government authorities were generally excluded from the refund because that money does not stay with the developer. The meaning of this decision is not that a buyer can automatically demand a full refund for every small change. Under RERA, the facts, the agreement, and the seriousness of the change are very important. Now, understand RERA Section 14 in easy language. This section states that the promoter has to develop and complete the project according to the sanctioned plans, layout plans, and approved specifications. Once the sanctioned plans, fixtures, fittings, amenities, and common areas are disclosed to the buyer, the developer cannot make major changes to the agreed property on their own whim. For additions and alterations related to an apartment, plot, or building, the previous consent of that specific buyer is necessary who has agreed to take that unit. For common areas or building/project level changes, the previous written consent of 2/3 of the allottees may generally be required, keeping the promoter excluded from the count. RERA also gives limited flexibility for minor changes. If a minor alteration is necessary due to architectural or structural reasons, verified by an authorized architect or engineer, and the buyer receives proper intimation, then the situation can be different. But the difference between a minor change and a major change is very crucial. A small adjustment to a door and changing an entire room size, access, area or parking identity are not the same thing. If the parking, open space, room arrangement or area on the basis of which the buyer made their decision changes substantially, then the nature of the bargain can change. A layout in property is not just a drawing. It tells you how sunlight will enter the house, how furniture will be placed, how much privacy there will be, and whether movement will be easy for the elderly or not. A reduction in room size is not just a difference in numbers. It can affect bed placement, storage, space for children's studies, and even family comfort. Changing the parking configuration is also no small matter. If the promised parking was accessible and the revised parking becomes inconvenient, both the buyer's daily life and the property value can be affected. Things like open space, garden access, entry exit and construction area are also a core part of the buyer's decision. It is on the basis of these features that the price feels justified. Therefore, when a developer says that there is a slight change, the buyer should immediately ask, where is this change visible in the approved plan and what is its written impact? The biggest mistake is relying on a verbal assurance. In real estate, verbal words vanish into thin air when a dispute arises. Paper, emails and signed documents become the strongest proof. A buyer must check the RERA registration number before booking. They should try to view the project details, approvals, completion date, promoter information, and file documents on the RERA portal. A brochure can be beautiful, a sample flat can be impressive, but the final legal promise is decided by the agreement and the approved plan. Therefore, it is necessary to match the brochure with the agreement. In the agreement for sale, one should carefully read the carpet area, payment schedule, possession date, parking details, specifications, cancellation clause, refund terms, and provisions related to changes. Many people sign in a hurry because the sales team says that it is the last unit or the price is valid only today. This very pressure can later become a costly mistake. If the developer shows a revised plan after booking, the buyer should not panic. First, they should compare the old plan, the new plan, and the agreement side by side. Then, they should see which category the change falls into. Is it a minor technical adjustment, or does it materially affect the identity, area, access, parking, and promised features of the property? They should demand a written explanation from the developer. Ask in writing why the change happened, which authority approved it, when it was approved, and whether the buyer's consent was required or not. If the developer says that the change had to be made due to a government approval, the buyer can ask for the copy of the approval, the revised sanction plan, and the architect's certificate. If a consent form is sent, do not sign it without understanding. Consent means that you are accepting the change. Later in a dispute, this very document can go against you. If the change is major and the buyer does not agree, a written objection should be sent to the developer. Traceable methods like email and registered post are better. After this, the buyer can consider a RERA complaint. A complaint can be filed with the state RERA authority along with the project and promoter details while attaching the facts and documents. But taking legal advice before a complaint can be useful, especially when the amount is large, the agreement is registered, a home loan is involved, or the developer is already offering possession. The basis for demanding a refund should not be just disappointment. The buyer will have to show that there is a material difference between the promised layout and the actual/revised layout. If the developer has used a misleading advertisement, an incorrect brochure, a false assurance, or committed an agreement violation, the buyer's case can be strong. The accuracy of the advertisement and prospectus is also important in the RERA Act. If a buyer pays an advance based on a false statement and suffers a loss, the question of compensation or a refund can arise. But the same relief is not granted in every situation. In some places, a refund with interest may be given, in some places compensation, in some places rectification, in some places delay interest, and in some places the complaint can also be rejected. MahaRERA's recent decision is important because it showed that if the bargain between a buyer and developer breaks down irretrievably due to layout changes, refund relief can be possible. A message goes out to developers from this decision as well. If changes occur in project approvals, communication with the buyer must be transparent. Hidden changes and late disclosures break trust. The developer should take clear consent from the buyer, document the changes properly, and should not keep an unnecessary gap between the marketing promise and the actual construction. The lesson for home buyers is even bigger. Do not buy a property simply by looking at the location and price. The approved layout, carpet area, parking, floor plan, and common amenities are equally important. Keep the booking form safely. Keep the allotment letter safely. Save copies of the brochure, email, WhatsApp communication, payment receipts, agreement drafts, final agreements, and RERA details. If a sales executive makes a promise, get it confirmed over email. Right. As discussed, please confirm parking, layout, carpet area and possession details. The reply can become proof. During site visits, photos and videos can also be useful, but legal strength comes more from documents. Therefore, it is necessary to bring every commitment into a written record. Buyers taking a home loan should also check the bank documents. Many times, a clue about the area and property details can be found in the bank valuation or technical report. If the layout change affects the loan approval valuation or resale value, the buyer should bring this point on record as well. Emotion is natural in a property investment, but the decision should be made through documents. The dream of a home is big, so the verification should be just as big. RERA gives protection to the buyer, but the buyer also has to remain alert. If you do not read the documents, do not check the approvals, and rely only on the brochure, the risk increases. If the developer is making a genuine minor change, the buyer should be practical. In large projects, small changes are possible due to authority comments, structural safety, or compliance. But if the usability, promised area, design, character, or amenities of the house are changing materially because of the modification, the buyer should not keep quiet. The most important point is that a refund is not granted through automatic emotion, it is obtained from the facts of the case. The authority will look at what the promise was, what changed, whether there was consent or not, and how much impact the buyer faced. Therefore, every buyer should make a file before and after booking. All documents should be kept date-wise in this file, so that in a dispute, the story can come forward with proof. Delays, design changes, area differences, and parking disputes are common in real estate. But due to a lack of awareness, a buyer often gets scared and compromises. The purpose of RERA is precisely that buying a house should not depend on the mercy of the builder. The buyer should get information, transparency, and a legal remedy. This case of MahaRERA shows that layout and design are not small cosmetic things. Many times, they are the soul of the agreement. If the developer changes that soul, the buyer can ask, "Am I getting the exact same thing that I had booked?" And if the answer is not clear, the documents do not match, and the change is major, the path of RERA can open up for the buyer. But before walking on this path, patience, paperwork, and proper advice are necessary. A documented complaint is much stronger than an emotional fight. In the end, the matter is simple. A house is not just the name of walls and a roof. It is a combination of layout, light, space, parking, comfort, and trust. If the developer changes this trust after booking, the buyer is not helpless. RERA gives them the right to ask questions, raise objections, and demand a refund in a genuine case. Therefore, whenever you book a house, do dream, but read the papers with just as much care, because in real estate, a dream is safe only when the documents are strong. And remember, the strongest foundation of a house is built not with cement, but with a clear agreement, an approved plan, and written consent.
This video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible. But in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.